All right, let's go ahead and talk about pretrial proceedings. So this is going to be anything that happens before the actual trial of somebody who is accused of a crime. So it starts with the formal process of making a police record of an arrest. So this is, of course, known as booking. During booking, the accused is asked to provide personal information such as name, address, social security number, all that sort of thing, place of employment, and details about any other previous arrests that they may have had. Now, during the booking process, the accused is photographed, they're fingerprinted. There might be other tests that they have to undergo, such as fingernail clippings in some cases, writing specimens, blood samples, and excuse me, and sometimes even urine tests. So the accused must appear before a judicial officer, typically a judge or a magistrate, and that is when their charges and their rights are explained to them. So at this time, the defendant is actually appointed with an attorney. They're given the opportunity to obtain one themselves if they so choose, and bail may also be set at this point by the judge. Now, there is a Supreme Court decision that guarantees that people with lower incomes are guaranteed the right to free counsel at trial. That Supreme Court case is very important, and it is Gideon v. Wainwright. So Gideon v. Wainwright is going to guarantee free counsel for individuals at trial. Now, this right does not extend to the initial appearance, because this is where you would then determine what kind of counsel you would like. So often, individuals with lower incomes are subject to higher bail and might spend more time in jail before the trial because they do not have adequate legal representation at the initial appearance. Now, in the case of a misdemeanor, the defendant is asked to enter a plea of either guilty or not guilty at the initial appearance. Now, in the case of a felony, an individual does not enter a plea until a later date, which is known as the felony arraignment. So with a misdemeanor, you enter a plea right at your initial appearance. With a felony, there is a later time when you would actually do that. So bail and pretrial release. So an arrested person can usually be released after putting up an amount of money that is known as bail. Once again, this is not a get-out-of-jail-free card. It is just to ensure that an individual will actually return for trial. Now, bail is guaranteed as a right, except in instances of most serious crimes such as murder. It is paid directly to the court, and in some jurisdictions, a defendant may actually be released for paying a portion of the bail, typically that being about 10%. That's the most common figure. If the accused fails to return for trial, the court ends up keeping that money, so you surrender that money. In some cases, the defendants may be released without having to pay cash bail. So that is known as personal recognizance. And you need to promise that you will return for trial, and this is usually for people who are considered to be a low risk of failing to show up for trial. Also, people who don't commit violent crimes. So typically, if you're going to commit a violent crime, you would not be eligible for personal recognizance. So when determining an individual's likelihood to return, a judge considers a lot of different factors, such as the nature and circumstance of the offense, a person's family and community ties, their financial resources and employment background, as well as the defendant's prior criminal record. So lots of factors to determine bail versus personal recognizance. So, the next thing that's going to occur for a misdemeanor is that a defendant proceeds based upon a prosecutor's information. Which is going to detail the nature and circumstances of the charge. So it is a formal criminal charge that is brought out by the prosecutor, and there is no preliminary hearing or grand jury. A defendant is charged with a misdemeanor, and they're not entitled to a preliminary hearing or a grand jury review. So what is a preliminary hearing? A preliminary hearing is a screening process used by about half, I did it again. Used by about half of U.S. states. The purpose is to determine whether there is enough evidence to require the defendant to stand trial. Basically, is there enough information that works against the defendant that they can proceed with a trial? It is the job of the prosecutor to prove to a judge that a crime was probably committed and that the defendant was the one who probably committed it. The defendant has the right to be represented by an attorney at preliminary hearings. They also have the right to cross-examine prosecution witnesses and call their own favorable witnesses. So if enough evidence is presented to support the prosecutor's case, the case will actually proceed to trial. Now, if the judge feels that the evidence does not support the theory that a crime was probably committed by the defendant, the case will then be dismissed. If the case is dismissed, this doesn't necessarily mean that the case is over. The prosecution can still submit the case possibly to a grand jury for a review of any charges. So what a grand jury is. A grand jury is made up of a range of 16 to 23 people, and they are responsible for determining whether or not there is sufficient cause to believe that a person has committed a crime and should stand trial. So about half of U.S. states use grand juries instead of preliminary hearings for serious crimes. Some states use both. Delaware uses both. So in a grand jury proceeding, neither the defendant nor his or her attorney has a right to appear. So just to make this clear, this is very strange because the defendant's not there, the defendant's attorneys are not there. A judge is not present for these proceedings either, and the rules of evidence do not apply. So rules regarding what is admissible, what is not, they do not apply. So it is just a prosecutor in a room with 16 to 23 grand jurors who are going to determine whether or not this case has enough evidence to proceed to trial. So a prosecutor is not required to present all of the evidence or call all witnesses, as long as the grand jury is satisfied with the evidence presented. All grand juries are secret, and their work is not public. So it is a very closed process. Now, the grand jury has historically been seen as the guardian of the rights of the innocent. So if a majority of grand jurors do not believe adequate evidence has been presented, the case is then dismissed. So they need to make sure that a majority of grand jurors believe that there is a case in order for this to proceed. Felony arraignment and pleas. So after an indictment or information issued, a defendant is required to appear in court to enter a plea. Now, if they plead guilty, the judge will set a date for sentencing. If they plead not guilty, the judge will set a trial date. There is another type of plea that we had mentioned before. It is the no contest plea, which is known by its proper name, nolo contendere. So this is a plea in which the defendant does not admit guilt, but doesn't contest the charges. It is basically the same as pleading guilty. However, they do not admit any sort of guilt. The advantage here is that evidence from this particular case, well, we'll put it this way. By not admitting guilt in a criminal trial, you do not allow that to be used against you in a potential civil trial based on the same matter. So in a civil trial, you could make the argument, if you are the defense, saying, this individual pled guilty. Obviously, there is an admission of guilt. But with a no contest plea, you never actually admitted guilt, so it cannot necessarily be used against you in the same way in a civil trial. Pretrial motions. So a motion is a formal request that a court make a ruling or take some other action. So there are some pretrial motions that can be issued, such as a defendant filing a motion to have the case dismissed, filing a motion to examine evidence in possession of the state, so if the state has evidence and the defense wants to see it, filing a motion to change the trial date or location, or filing a motion to suppress certain evidence, maybe because it was unlawfully obtained, maybe because it is more prejudicial than probative. The Fourth Amendment protects citizens against unreasonable searches and seizures by the government. This has historically been backed by the exclusionary rule, which states that evidence illegally seized by law enforcement cannot be used to convict the accused at trial. It also applies to evidence obtained from illegal questioning. Plea bargaining. Most criminal cases, in fact more than 90%, never actually go to trial. This is due to the fact that most defendants charged with a crime plead guilty before the trial. This is known as a plea bargain. So the defendant will plead guilty in exchange for certain concessions. So typically in exchange for a guilty plea, the defendant pleads guilty to a lesser charge, or the prosecution recommends a lighter sentence. Now, judges have the power to reject plea bargains if they feel that the plea was not made freely, voluntarily, and with knowledge of all the facts. So it is possible for a judge to reject a plea bargain. So that is what we have for the pretrial proceedings. If you have any questions, please feel free to drop by my office hours. Ask any questions via email or on Campus Messenger, and I'll talk to you tomorrow.